capacity in this plan to a rollover IRA. So where you may have a process where the focus of some firms is the retirement plans to get to the rollovers, well, that kind of just threw a wrench in that plan because that may very well deemed a prohibited transaction. And so that's what's being defined out right now. So as you're in places with advisors, this is something that is very, very, very big. Biggest change as far as expanding the scope of who's a fiduciary and what prohibited transactions are. So when we're talking about it, it's something that's going to really change the marketplace. 20 years ago when I entered the retirement area on the sales side, going from the third-party administrator, you didn't have these types of concerns. Anyone could be the advisor on a retirement plan. For a 403B plan, you required a little more licensing, but it was still open to about anyone. Now it's narrowed the scope of who can be an advisor, and this is actually going to really, really narrow it down on who's qualified as an advisor and who just does not have the qualifications to act in that capacity. And even though right now they're able to say, I'm not providing any investment services to the plan, but I'm paid on the plan, well, it may very well be that because you're paid on the plan, you're now defined as a fiduciary of that plan. So that's what's going through the pipeline right now, and that's what the House is trying to evolve, because it's taking place from the top down. There's no one interviewing people from the retirement plan industry to say, hey, what needs to be fixed or how should we approach this? It's actually a top down where they've come up with an idea and they're going to run with this idea, and they're not interested in any feedback from the industry, from American Society of Pension Professionals and Actuaries. They're sort of doing this very independent of the industry. So that's where the definitions are going to change, and then undoubtedly for the CPAs in the room, your roles are going to be evolving a little bit more compared to 10 years ago when you really didn't have to go that deep, to now when you're really almost signing away your life with some of the things that you really have to make sure you have a clear understanding. For example, the level 1, level 2, level 3 investment choices 20 years ago, that wasn't something you really had to pay attention to. Now I hear comments from auditors about, although it's a fixed account and other auditors will call this a level 2 investment or a level 1 investment, there's auditors that are saying, I'm not comfortable with the ability to value that asset, so I'm going to make it into a level 3. And then the battles begin because the vendor won't want it to be listed as a level 3 where it may not be as easy to value as they're describing. The things that can throw a wrench into that would be some sort of a put or a deferred sales charge on the cash type option. So that may make this a little bit more difficult going forward. I have 3 steps to help protect yourself, fellow fiduciaries and participants. One's create or strengthen your investment policy statement. Making sure that it's up to date. If it was written 10 years ago, it's based on the practices of 10 years ago, but they're not based on today. So there's things that you wouldn't want to mention. So what didn't exist 10 years ago? Well, let's see, we've got target date funds were pretty brand new to plans, so they may not have been addressed in the investment policy statement. Index funds may not have been addressed in the investment policy statement. Social responsible funds, those also, although they may be in the plan, they may not be mentioned or addressed in the investment policy statement. The second one is appointing a fiduciary committee. It could be an individual, but more and more we will see 2-3 people that are part of the committee that evaluates the retirement plan. And it's great because it gives you eyes from different aspects of the plan, from the plan sponsor's eyes, potentially a participant committee member, an HR committee member. And then partnering with a provider that either offers a high level of support and impartial advice while retaining revenue neutral. So meaning that you're partnered with the right provider that gives you the flexibility to make the changes to your plan to fulfill your roles as a fiduciary. And the examples I'll give you will be, you discover that a series of funds are underperforming, you try to replace the funds, but the vendor, it's their own funds, and they're not going to replace them. So now you're put in a spot where, remaining with that vendor, you're not able to fulfill your role as a fiduciary to potentially swap out the funds with better performing funds. And it's being aware that those situations will come up, and then also looking at the capacity that the vendor may be taking, your advisor first, but also that the vendor may be taking in regards to the 401k or 403b plan. So are they signing on as a 321 fiduciary, which would be the guy that's a blanket, I'm blessing the funds, and I've reviewed the funds and I'm comfortable with their performance versus their peers. Or are you looking at a 338 fiduciary, which is someone that will not only bless the funds, but on top of that, will take on the responsibility for removing and replacing funds, and sign on as the person that's making the decision on creating the lineup and also removing and replacing funds. You know, creating the lineup is half the battle. The other half, though, is pulling the trigger and knowing when to replace a fund and who's going to act in that capacity. And a lot of times we'll go out to plan sponsors and ask who's making those decisions, and they'll say, well, our advisor is. Their advisor happens to be with a broker-dealer that won't allow them to take on that type of a fiduciary role. So they think the advisor's doing it, when in reality, the vendor knows that it's actually the plan sponsor on the hook for those decisions. But again, partnering with the right people to do this. I don't need to go over page 8, which is really showing you the difference of 1% more in fees over the lifetime of a participant's account. But I think more important than that is on page 11. It's a checklist for fiduciaries, and it's just a basic checklist of basic criteria and basic things that you should be looking at and be aware of, and really know your plan and know these items about your plan. So signed and dated IPS, all the funds in the plan are covered by the IPS. Again, where you have social responsible funds, they're underperforming their peer group of mid-growth, but having the wording in yours that allows for you to have this investment choice based on the social nature of the funds, not on the performance. And so making sure that all the investments are covered under that IPS. Investment review process, making sure that you've got some sort of quarterly monitoring where you can document this. Again, just having a giant stack and saying, here's our proof. You want to have it a little more organized. Most vendors or platforms will provide you a very detailed quarterly report of the investments, the performance versus their peers. Some of the vendors will also take on a role to make recommendations, when to put a fund on a watch list. You know, the idea behind it is having an investment policy statement to take away someone having to decide on their own, should we get rid of it or should we keep it? And the problem you run into with that is over time, you know, if you don't have this in place, you may be keeping funds in the plan because you liked them, they performed well in the past, although their current performance is not up to par. So, you know, where some individuals can get sentimental about the funds, where this is a way that you take a step back and you're not making decisions based on, well, I really like this fund, I made a lot of money with it, you know, over the last 15 years, but its current performance is poor. The IPS is where you're documenting its performance and then you're taking action. The worst thing in the world you can do is have an investment policy statement and then not actually follow it and not actually make the changes that it's recommending. Defining out the investment committee, having meetings for when you get together to discuss the investments. Again, having that all, it's not necessarily about having the least expensive of anything. It's more about having a process in place that you're running your clients through. You know, I'm talking to you as plan sponsors, but I'm also talking to you as those auditing plans, that it's just all about having the process in place. And so there's nothing that says you have to have the cheapest 403b plan or 401k plan. It just says that you have to have a process that you're running through to make sure that it's within what would be a reasonable expense, which of course is done up somewhat vague. It's sort of up to you to come up with, you know, here's how we're showing we made the selection, and it may not be the least expensive, but it has some services that we're looking to provide to enhance our platform, provide more services to our employees, and things like that. 404C compliance, you know, 404C is been around for coming up on 20 years. It's really the first level of protection a plan sponsor had to protect themselves from the employees making bad decisions with the investment choices. And so the most basic nature of 404C, if no one's, you know, you may not have heard it in a while, but would be providing at least 3 core investment choices and give the employees at least the ability to make changes to the investments on a quarterly basis, and then finally providing ongoing education. So those are the three high-level points. If you were to talk to an ERISA attorney, they would be able to list out another 29 under those three. And then they would probably be able to say, I've yet to come across a plan that passes 404C, meaning that they're always going to find something that's not in compliance with what they view. But again, going through and seeing, is your plan 404C compliance? It's someplace that's marked on the document to, clarify and make it clear that you have a 404C compliant plan and you're running in that direction. Qualified default investment alternatives, believe it or not, you still come across about 25% of the 403B plans that come across don't have a defined QDIA. It's still the older model where it's defaulting to a fixed or cash option. And then managing the investment advisor, doing the due diligence on the person that's providing you the work on the investments, the investment evaluation, making sure that they're qualified to do the work and that they're providing a value. In other words, if they're paid from the plan assets, we want to make sure that it's defined what role they're providing to the plan sponsor if they're paid from the plan assets. Now I could go back 15 years, 12 years and recall Schedule A's, so on insurance company products, and 20 years ago you'd see one name listed, the advisor, and then what they were paid. Then it changed to the advisor, and then maybe an override from the vendor, and then maybe some special arrangement. And you had all these things laid out, but they weren't disclosed up front with the plan sponsor. Now with 408B2, that's and 404A5, now that's clearly defined. So the duties as an advisor is providing to a plan. It says I'm being paid 0.5%, and it's based on providing these services to the plan. And if there's any other compensation, no, this is what the service agreement says that they're providing to their clients. This is what we're being paid. So there aren't any more surprises. So you don't see those types of things that would make the cover of the Los Angeles Times about excessive fees in retirement plans. And that's what I had. There was one other item on, I wanted to touch on with not-for-profits specifically, and that's there's a debate that goes on between, do you exclude part-time employees from the plan from ever being eligible, and those are those working less than 20 hours a week, or do you include them but then exclude them from the company match? So, and again, I can't say that either of them are wrong, that both of them are right, but it's something that's popped up more frequently in, do we just make this available to everybody, whether they're working greater than 20 hours a week or not, and then exclude them from the match? Well, what I'm finding, my experience has been plan sponsors excluding employees from the match. That's a place that they can make a mistake. There's got to be somebody that's got a handle on that, that knows that at the end of the year or along the way that this is a person that's working less than 20 hours a week, and so they're not entitled to the match. I actually take the opposite side of it, where I look at it from the standpoint of not-for-profits. When they hire part-time employees, they're classified and hiring them for a particular role that's part-time. So they're already tracking them in their systems as a part-time employee. I find it's far easier and less mistakes to actually exclude them from the plan and then not have to figure out if you owe them a match or not. It's just easier to exclude them from the plan. When the day comes that they move on to be hired as full-time employees, then of course they're going to have to count from their original date of hire. But again, that seems to be the best practice, that we find there's less errors that have to be corrected by, because it's really easy to forget to take somebody's match, or maybe you have to give someone a match. So, any questions?
Yeah, I have one more.
Sure.
Getting back to my fee, about me, it's all about me. In the case where we had one provider, whether it be Lincoln or Prudential, whoever it was, and the company makes no match, we just send them, people decide on what they want to do, and what investments they choose. We just send the money. Would I be responsible for reviewing, in general at least, the performance of those investment options that this one company makes available to our employees to see whether those are reasonably,
So that's the catch-22.
remunerative or?
So that's the catch-22.
Yeah.
It's basically what you're
It
saying.
sounds like I would have some responsibility.
Well, right now, with a non-ERISA plan
Yeah.
that doesn't file a 5500,
Right.
that's not your responsibility. You're not on the hook for monitoring the investment choices.
I can imagine an employee though that's saying, look, you gave me these lousy investment options, I put my money in there and I got nothing back.
Well,
How come you didn't
Yeah,
tell me
that's
that I could
exactly
do
it.
this?
So that's how it stands right now, but this definition of compensate, or definition of a fiduciary, this evolution that's taking place, that may not be the way it is. Other states are able to narrow it down on voluntary plans to one vendor. And guess what? They go through and monitor them and evaluate and then come up with who that is going to be. And then they'll be able to run with one vendor. But California, and I believe Texas, and another state are ones that don't do that. So right now, not taking on that role, although you want to help and you want to do the right thing for the employees, but at the same time, that would potentially cross the line to make you a fiduciary.
Yeah,
and that non-ERISA
there's a
plan-
downside to getting involved, because
Correct.
then the expectation is that you're going to continue to be involved and make
Well, and then depending on
appropriate
the,
judgments.
depending on the size of the organization, suddenly you become an ERISA plan and you've got greater than 120 employees and terminated participants with account balances, and suddenly you're not only exposed to the cost of an administration fee for the plan in the 5500, but you're also going to have a large plan audit, and so you'll have some
more
surprises.
responsibility.
Now, after the new definition, that might be a good time for defining, the changes that take place as of that. That might be a future idea for a topic, because that's something that's a really, really, really big change. And I can talk about it now, but when it comes down the pipeline, it's going to really revamp who can work with plan sponsors in regards to the retirement plans.
Thanks very much.
And who can't.
I wanted maybe just some feedback or a talking point, because I know, and I probably do the least amount of the pension audits here, but I know we came across in doing the financial audit, like a client that had their plan doc, and actually their plan document, and actually had been acting practically in a different way. And so they actually approached their TPA to redate, to go sort of back, because what they actually had been doing practically was contrary to what the document had stated. And it had been their practice for a while, so it wasn't just like they decided to say, hey, forget the document, we're gonna do it this way. In practical application, they had been doing it that way for a little while, so they were like, well, maybe we should go back and make the plan reflect what our actual practice is. And do you see that type of?
So I would see it like,
Because
I would see the corrections going forward where we would fix the document to back what they're doing as far as how they're administering the plan. But then the challenge is going back and making the correction for prior years. There's something called a Scribner's error, and unless you actually call out the vendor or the TPA on that, it's something that may be a way that you could say that this was actually just a mistake on the document that we didn't catch.
Now
Now,
their intent to operate that way, and they just didn't make the plan.
now if it's gonna make it where the participants are missing out on $30,000 of something, then I don't know that would fly. But if it's just for something that's more of an administrative error, then you may be able to run it as a Scribner's error. That's one of those secrets that no one will ever talk about, but it'll pop up once in a while. I'd be worried though if they went back and then rewrote the document and post-dated. That would make me very uncomfortable.
Right, and then there's the exposure of, have you done something now and restating it that, like you said, has harmed.
Correct.
In terms of practical application versus what the document said, that now an employee who was acting off of the old document or the document they were provided, that would have now changed something that was going on.
Yeah, so that's where, I don't know, that's something where it gets to be be touchy because when you're coming in and you're reviewing the document and they're doing it this way, you're sometimes viewed as the bad guy when all you're doing is just interpreting their document. I had a situation with a 401k client that was, we went through and did the call to review the definitions of compensation, review that the match is on an annual basis. And lo and behold, they've been administering it, and the prior vendor was administering it as it were a annual basis, or on a per pay period basis, not an annual basis. So, going forward, we amend the document to fix it, but we can't make the plan sponsor do the right thing of correcting and funding what they're supposed to fund from the prior 2 or 3 years.
Right.
You can lead a horse to water, but I can't make them make the correction. And then they would argue that their side of it is the way they've been administering the plan. And they feel that's a defensible position. The reality it was a cheaper position than actually going through and correcting it the right way. So, it made me uncomfortable with that, especially knowing that we had gone through this 2.5-hour document called a review of the document. On the not-for-profit side, there's lots of things on 403B plans specifically that are left over from when the regulations were different. And the example that I'll give you is one of the more difficult things that cause a lot of mistakes are hardships. So, hardships sound pretty easy, right? You got specific 5 or 6 safe harbor definitions of what a hardship is: void eviction, avoid foreclosure, purchase of primary residence, burial expenses. There's a few others that fall under that. It counts as a hardship. So then you have someone at the plan sponsor usually, or at the vendor, that's going to collect that information to determine if it's a hardship. And then the way it's written, when someone takes a hardship, they've already had to exhaust their loans, they take a hardship, they're going to need to be suspended from participating in the plan for 6 months. So who tracks that? So it's not something the vendors are going to be able to track, and it's not something that I would want to rely on the plan sponsors to track either, because that's a place that's a really easy error to make. Well, you don't have to have them fall under the safe harbor definitions. You also have another category of hardship that's called facts and circumstances. And I'm going a little technical, but this is just sort of like the little consulting things that make life easier for a plan sponsor. So you don't put it under the safe harbor, you actually use those definitions from safe harbor and put them under what's called the facts and circumstances. And so as an example of like our company to automate loans, hardships, distributions, and then potentially take on an additional fiduciary role, that's one of the things that we're going to amend in the plan, because you eliminate the 6-month suspension. Again, why kick somebody when they're already down and had to do a hardship to where they're not going to be able to receive any employer contributions for 6 months? And that penalty used to be a year. And then I took over plans for a long time where it was still a year, even though the law had been changed to 6 months. Well, now here's a way we just take it out of safe harbor, run it through the same definitions on facts and circumstances, and then we've avoided that 6-month suspension, so there's not a place for the plan sponsor to make the error in not bringing them back into the plan when they're supposed to. But that's just another little, a little item in doing document reviews. There's things to clean up. And you'd be surprised, some of the stuff lingers back, that it just doesn't need to be in the document written the way that it's written. And there's ways to make things more administratively feasible.
Thank you very much.
Thanks.
So I definitely want to thank both Peter and Scott for presenting today and giving hopefully valuable information